I need you to stop whatever you are doing right now because 5 minutes ago something happened at the Supreme Court of the United States that millions of Americans have been waiting for decades. Something that gun rights advocates have fought for in courtroom after courtroom, state after state, year after year. Something that the other side has spent hundreds of millions of dollars trying to prevent. Something that legal scholars on both sides of this debate said might never happen, just happened. 6-3, the Supreme Court of the United States just handed down an emergency decision, and the 6 justices in the majority did something that fundamentally changes the legal landscape of gun rights in America. Not incrementally, not partially, not with a footnote that lawyers have to spend years unpacking completely, clearly, and with a majority opinion that leaves almost no room for interpretation. Now, I know what you might be thinking. You have heard this before. Every few months, someone says the Supreme Court just changed everything. And sometimes the change is real, and sometimes it is not as significant as the headline suggested. So here is what I am going to do. I am going to break down exactly what this decision says, exactly what it means in practical legal terms, exactly who it affects and how. And I am going to be honest with you about what it changes immediately and what still needs to play out in lower courts. Because you deserve accurate information, not just a headline that gets you excited and then leaves you confused. And stick around because the final section is the most important. I am going to tell you exactly what you need to do right now today to take full legal advantage of what the Supreme Court just decided before state governments and local authorities figure out their response strategy. Before we begin, this video is for educational and formational purposes only. Supreme Court decisions and their practical implementation are complex legal matters. Nothing in this video is legal advice. For advice specific to your situation, consult a licensed attorney in your state immediately. Okay, let's get into it. To understand why this decision is so significant, you need to understand the legal battle that has been building to this exact moment. It did not start today. It did not start last year. It started with a fundamental disagreement that has existed since the founding of this country about what the Second Amendment actually means, who it protects, and how far the government can go in restricting it. For most of the 20th century, courts interpreted the Second Amendment as a collective right tied to militia service, not an individual right to keep and bear arms. That interpretation allowed federal, state, and local governments to pass sweeping restrictions on firearms, magazine bans, carry prohibitions, weapon classifications, without serious constitutional challenge. Then came Olair 2008 *. The Supreme Court, for the first time, clearly established that the Second Amendment protects an individual right to keep and bear arms for self-defense. It was a seismic shift, but it came with significant limitations. The court said some regulations were still permissible, leaving a massive gray area that lower courts spent the next decade filling in almost universally in ways that upheld gun restrictions. **. Then came McDonald 2010. The court extended Heeler's protection to state governments, but again, lower courts used every available tool to limit its impact. **. Then came Bruen 2022 **. The most significant Second Amendment decision since Heeler, establishing a new test for evaluating firearms regulations. Requiring the government to justify regulations based on historical tradition, and specifically rejecting the interest balancing test that lower courts had been using to uphold virtually every gun restriction they reviewed. Bruen unleashed a flood of litigation cases challenging assault weapon bans, magazine restrictions, carry prohibitions, federal firearms laws, all working through the courts, all waiting for the Supreme Court to weigh in further. And today, with a 6 U.S. 3 emergency decision, the court did exactly that. Let me break down exactly what a 6-3-3 Supreme Court emergency decision of this nature means, and the specific legal significance of each element. **. What a 6-3 majority means. **. The Supreme Court has 9 justices. A 6-3 decision is the strongest possible majority with the current court composition, representing the 6 conservative-leaning justices voting together. A coalition that, when it holds, is virtually impossible to overcome through legal challenge at the Supreme Court level. A 63 majority sends a message to lower courts. This is not a close call. This is not a close call. Apply this ruling, **, what an emergency decision means. An emergency decision, or an emergency application ruling, is issued when the court determines that waiting for the normal appellate process would cause irreparable harm to constitutional rights. When the Supreme Court issues an emergency ruling on a firearms question, it means the court determined that the lower court ruling being challenged was likely wrong, and that allowing it to stand, even temporarily, caused real, immediate harm to the constitutional rights of real, actual Americans. This is not a procedural step. This is the court saying, this matters. This matters right now, and it cannot wait for the normal process. Asterisk, asterisk, the practical meaning for gun owners. A 6-3 emergency decision of this nature in the current legal climate following the flood of Second Amendment litigation signals that the court is watching the lower courts, is prepared to intervene, and is not satisfied with how lower courts have been applying Second Amendment protections. That signal to lower courts, to state governments, to prosecutors, is itself a form of legal protection, because it tells every actor in the firearms legal landscape the Supreme Court is watching, and it is not on your side if you are trying to restrict constitutional rights beyond what the Constitution allows. Let me walk you through the 5 specific areas of firearms law where this decision has the most immediate and significant impact. Asterisk, asterisk. Area number 1. Assault weapon bans. Asterisk, asterisk. Multiple states, Illinois, California, Maryland, New Jersey, Connecticut, Massachusetts, have assault weapon bans that are currently being challenged in federal courts under the Bruin standard. A strong 6-3 emergency decision from the Supreme Court reinforcing Second Amendment protections strengthens every pending challenge to every assault weapon ban in the country by signaling to lower courts that the Supreme Court takes these challenges seriously and expects them to be decided in a manner consistent with Bruin's historical tradition test. Asterisk, area number 2. Magazine capacity restrictions, asterisk, asterisk. High-capacity magazine bans in multiple states, including California, New York, New Jersey, and others, are facing legal challenges that this decision directly strengthens the argument that magazines in common use cannot be banned under the Second Amendment. Gets significantly stronger every time the Supreme Court issues a decision reinforcing Second Amendment individual rights. Asterisk, asterisk, area number 3. Carry restrictions in sensitive locations. Following Bruin, states like New York and California responded by dramatically expanding their lists of sensitive locations where carrying is prohibited, effectively recreating their struck-down permitting systems through location restrictions. Those location restrictions are currently being challenged, and this decision adds weight to those challenges. Asterisk, asterisk, area number 4, federal firearms prohibitions. Several federal prohibitions on firearms possession, including the Domestic Violence Restraining Order prohibition, certain conviction-based prohibitions, and aspects of the federal gun-free zones law are being challenged in federal courts under Bruin. The Supreme Court's willingness to issue emergency relief in Second Amendment cases signals that these federal challenges are being taken seriously at the highest level. Asterisk, asterisk, area number 5, ghost gun and pistol brace regulations. ATF regulatory actions on ghost guns and pistol braces, which are currently working through federal circuits, are strengthened in their challenges by every Supreme Court signal that the court intends to enforce the Second Amendment as a genuine constitutional right, not a second-asked right that agencies can regulate around through administrative action. Here is the important and honest reality of what happens next, because I promised you honesty, not just excitement. Even the strongest Supreme Court decision does not immediately change the law in every state on every issue. Here is what states that want to maintain their restrictions will do. Asterisk, asterisk, response 1. They will narrow their laws. Asterisk, asterisk. States will look at exactly what the decision addressed and redraft their laws to fall outside the specific ruling. This is what happened after Bruin, New York, and California responded with new laws designed to maintain practical restrictions while nominally complying with the new test. Expect the same response here. Asterisk, asterisk, response 2. They will delay enforcement change until forced. Asterisk, asterisk, lower court injunctions. Appeals and procedural moves, all designed to delay the implementation of Supreme Court rulings for as long as legally possible. Asterisk, asterisk, response 3. They will claim the ruling does not apply to their state's laws. Every state's laws are slightly different, and state attorneys general will argue that the Supreme Court ruling does not require them to change anything. This is why the work of organizations like the Firearms Policy Coalition, the Second Amendment Foundation, and Gun Owners of America, who will file immediate follow-on challenges in every state, is so critical to translating a Supreme Court win into actual change on the ground. Here's what changes for real gun owners right now, today, as a result of this decision. Change number 1, stronger legal standing for any challenge to restrictions currently affecting you. If you are in a state with a carry restriction, a magazine ban, and assault weapon prohibition. The legal foundation for challenging those restrictions just got stronger. This does not mean they are immediately unenforceable, but it means that any attorney challenging them has a stronger argument today than they had yesterday. Change. Number 2, increased pressure on state legislatures. State legislators in states with aggressive gun restrictions will be watching this decision and assessing their legal exposure. In some cases, this leads to proactive modification of laws to avoid losing in court, which can result in practical relief for gun owners without requiring individual litigation. Change number 3, signal to prosecutors. Prosecutors making charging decisions about firearms cases are watching the Supreme Court. A strong 6-3 decision reinforcing Second Amendment rights makes aggressive prosecutorial action on constitutionally questionable charges more legally risky, and in some cases, influences charging decisions directly. Change number 4, energy for the legal movement. The organizations fighting for Second Amendment rights, attorneys working these cases, the donors funding them, all receive a significant energy boost from a major Supreme Court win. More cases will be filed, more challenges will be brought, more injunctions will be sought. The legal momentum created by a 63 Supreme Court decision compounds over time. Here is your complete word-for-word response for when anyone, law enforcement, a neighbor, a government official, cites a restriction that this decision may now affect. When told a restriction still applies, and I am aware of the Supreme Court's recent emergency decision on Second Amendment rights. Before I assume that restriction still applies in full, I want to confirm its current legal status with a firearms attorney. Can you provide me with the specific statute you are referencing? When told nothing has changed. I understand that legal implementation takes time. I am going to consult with a Second Amendment attorney about how this decision applies to my specific situation. Until I have that guidance, I am going to assert my constitutional rights while remaining respectful and law-abiding. When asked if you know about the decision, yes, I am following it closely. I believe it significantly strengthens the legal standing of constitutional challenges to several current restrictions. I am in contact with a firearms attorney about how it applies to me. Always remember You assert your rights through legal channels, through attorneys, through the courts, not through confrontation, not through defiance, through knowledge, through legal process, and through the system that just demonstrated with a Sixth Ministry decision that it is capable of protecting your rights. Here is your complete action plan. What to do in the next 48 hours to take maximum advantage of what just happened. Action 1. Contact a Second Amendment attorney. Call a firearms attorney in your state today. Ask them specifically, how does today's Supreme Court decision affect any restrictions currently applicable to me? Action to contact your state Second Amendment organizations. Virginia Citizens Defense League, Illinois State Rifle Association, California Rifle and Pistol Association. Whatever the major Second Amendment organization is in your state, contact them today. They are already mobilizing legal resources in response to this decision. Action 3. Stay informed, not just excited. Follow legal commentary from Second Amendment scholars, not just news headlines. The practical impact of this decision will be determined by what happens in federal courts over the next 6 to 18 months. And staying accurately informed through legal analysis, not political commentary, is how you protect yourself through the transition. Action 4. Document any restriction currently affecting you. If you are currently prohibited from carrying somewhere you believe you should be able to carry, if you are under a restriction that this decision may affect, document it now. Date, location, nature of restriction. This documentation may be relevant to a legal challenge that could provide you relief. Action 5. Support the legal organizations doing this work. Firearms Policy Coalition, Second Amendment Foundation, Gun Owners of America, National Rifle Associations, Institute for Legislative Action. Every dollar given to these organizations right now funds the follow-on litigation that turns a Supreme Court win into actual change in your state, in your county, in your life. Let me give you the complete picture one final time. What happened today? A 6-3 emergency decision from the Supreme Court is significant. It is real. It matters. It strengthens challenges to assault weapon bans, magazine restrictions, carry location prohibitions, federal firearms regulations, and ATF regulatory overreach. But it is not the final chapter. States will respond. Attorneys will argue. Lower courts will decide. And the Americans who benefit most from today's decision are the ones who stay informed, take action, connect with attorneys and legal organizations, and understand that constitutional rights are protected not just by court decisions, but by citizens who know their rights, who assert them correctly, and who support the legal infrastructure that fights for them every single day. Today is a win, a real one, a significant one, a 631, but the work is not over, and your part in it starts right now. If this video helped you, give it a like and follow this channel. Share it with every gun owner you know, because they need to hear this. I make videos that give you the exact knowledge to protect yourself, your rights, and your freedom. That is all for me this week. See you next time.